Hi, I'm Jay Lutzky. I'm an attorney. People have asked me, can I transfer personal property to someone else and then file a bankruptcy? The short answer is no, or maybe. If you transfer property to someone, you have to get an equal amount back. For example, let's say you had a TV set and you want to give your friend a TV set, and this TV set's worth $200. Not what you paid for it, what it's worth that day. And you give your friend the TV set for $200 and they give you $200 back and you put it in the bank. That's fine, because you've traded equal for equal. TV set for $200 for $200 in cash. But let's say you want to give someone a TV set and not get anything back. You want to give it to your cousin. Say, here, have my TV set. And then you want to file a bankruptcy. That is not proper, because that's a transfer given to someone without consideration, without getting something back. And the court will not accept that. You have to list it on your bankruptcy if you've made any transfers, when you made the transfers, what it was, and what you got back for it. If you give someone a gift, like a TV set or a big item, that's not acceptable. However, if you give someone a gift, for example, your child has a birthday and you give them $25 or you buy them a new bicycle, that's fine, because that's a normal situation. Now, if it's a fancy bicycle that costs thousands of dollars, that's not acceptable. It depends on how much the item is worth. So you need to be very careful. Regular gifts are fine. If you are not sure, you'll talk to your lawyer what the gift was, how much it was, when it was, who it went to. And possibly, if you're contemplating a bankruptcy, we may have to delay the bankruptcy if you gave a large gift, that enough time has passed so the court doesn't care because it's beyond the limits. If you gave someone something years and years ago, that's fine, because that's before the applicable time period to make a gift. So if you're contemplating a bankruptcy and you want to keep personal property, first talk to your lawyer. Also, many items that are personal property, you can list in the bankruptcy as an asset, which means what you own, and you can list it as an exemption, which means you can keep it. It depends on the dollar value of the item, what it's worth now. Not what you paid for it, but what it's worth now. And in New York State, you could use the wild card exemption, which allows you to keep a significant amount of money that may not be specified in other deductions or exemptions. So before you start making transfers to people, talk to a lawyer to go over to see if it's proper. And if you've already made the transfer, likewise, talk to the lawyer. Come in and see me. We'll see what you transferred, how much it was worth when you transferred, when you transferred, and if it's something that would pass muster with the court. And of course, we have to disclose everything to the court, because you're signing those papers as well as your lawyer, and it has to be accurate, it has to be honest, it has to be truthful, because you're signing on the penalty of perjury, risking a $250,000 fine and or imprisonment, which is a federal crime. I'm not going to let you do that. I'm going to make sure it's careful and accurate and not jeopardize your safety, your freedom, or your money by making a mistake on your bankruptcy. So when you're ready, let's talk. We'll analyze the situation, what items you have, if you're going to transfer, what it's worth, if you have transferred, when you transferred, what the item is worth. Look forward to talking to you in the near future. Thank you.